Greetings, everyone. A very warm welcome to all our participants, judges, and observers joining us today for the grand final round of the Family Harmony Mediation Challenge 2025, organized by Mediate Guru. This is a proud moment for all of us as we witness a specialized mediation competition focused entirely on family disputes, an area that lies at the very heart of human connection and societal harmony. I will be your moderator for this session. The Family Harmony Mediation Challenge 2025 is a pioneering initiative by Mediate Guru to promote the art and science of peaceful resolution in family disputes from issues of marriage and property division to co-parenting and intergenerational relationships. This competition is inspired by Mediate Guru's vision of sharing the gift of mediation with the world. We are truly privileged to have with us our esteemed judges, distinguished professionals, and experienced mediators who have graciously devoted their time and guide and evaluate today's session. We are grateful to have with us Mr. AJ Jawad, Registrar at IAMC Hyderabad, Ms. Pooja Anand, internationally accredited mediator, Dr. Ashu Dhiman, Assistant Professor of Law at WIPS, Ms. Reema Bhandari, Senior Trainer at MCPC, Ms. Kathleen Ruin Leedy, US and IMI Certified Mediation Trainer, Ms. Maureen Erickson Robert Shaw, International Trainer on Mediation. Thank you, respected judges, for joining us and for your continued support in nurturing the next generation of mediation experts. Here is a quick overview of the round format before we start with the session. Each mediation session will last 90 minutes. Please note that the timer will be maintained by the moderator and reminders will be shared in the chat box as we progress. After the session concludes, we will move to a brief feedback session from the judges. Participants are requested to stay muted when not speaking and ensure a professional decorum throughout the round. With the permission of our honorable judges, we shall now begin with the mediation session. I wish you all the very best. May your approach reflect patience, compassion, and the true spirit of mediation. Mediators, you may just proceed with your opening statements. Three, two, one.
Thank you. Good evening. I would like to welcome both the parties to this mediation session. We really appreciate your presence, especially with it being a Sunday evening. My name is Kylie, and I'm joined here today with my co-mediator, Miss Haley. Please feel free to address us by our first names, and you may now introduce yourselves as well as how you would like to be addressed.
Good evening, everyone. I'm Dr. Meera Rao, and my pronouns will are she and her.
Good evening, everyone. My name is Christo, and I'll be representing Dr. Meera in today's session. You can refer to me as such.
Good evening, everybody. I am Jonathan Blake. Please feel free to call me Jonathan. I'm the fantastic participant in today's discussion. Thank you so much for being here.
Good evening to everyone. My name is Nila, and I'll be the counsel for the responding party. That's Jonathan Blake for this session. You can refer to me by my first name or counsel, whatever you prefer.
Thank you so much, Ms. Rao, Mr. Christo, Mr. Blake, and Mr. Nilay. To begin with, I would like to congratulate both the parties for deciding to amicably settle their dispute through mediation as opposed to litigation. As we all know, I'm sure the councils are well aware of how strenuous that process is. I would also like to preface by stating that we are certified mediators with many years of experience in mediation. And I also hope that there's no conflict of interest. If anyone feels that there is so, they may say so now. A thumbs up would do. Great. Also, do the parties present here today have the power and the authority to be present here today and to be making decisions? Again, a thumbs up would do. Amazing. So since today's discussion will be revolving around family, let me bring in an example that's relevant to the conversation to really help you understand what mediation is. So right now, it feels as though both the parties are standing on opposite sides of a riverbank. Mediation is not about deciding which bank is right. It's about building a bridge strong enough for both of you to meet in the middle. The bridge is not built with concrete, but with understanding, patience, and honesty about what really matters. Each conversation we have today lays one plank of that bridge. The stronger we make it, the easier it becomes to cross together, even if you later walk in different directions. What I'm trying to say is mediation solves through its structure. It gives both the parties a space to share their own situation and what they actually want. And when you understand the whole picture, you will definitely see that there's no situation that's win or lose. There is always a way in which both the parties will get to win, as you will not be forced to agree to any settlement which you are not comfortable with. We are simply here to implement and to give structure to the process, or the skeleton, you can say. You will be in charge of the outcome or the meat of the process. We are just here to clarify, take notes of figures, and to summarize what's going on. If you are lost or you need a breather, we are always here and happy to help. We may be taking notes or referring to some documents on our laptops, but we are always listening. Now, my co-mediator, Ms. Haley, if you could go on to further explain the process of mediation, just to ensure that we're all on the same page today.
Thank you so much for setting us up in such an informative way. Yes, I'd like to reiterate that mediation is a voluntary and confidential process that creates space for real conversation outside the court. It's a chance to step out of an adversarial frame and into a problem-solving space. It's about exploring options, expressing needs, and deciding together if there's a resolution that works for you and your family moving forward. As said, we're neutral facilitators and we aren't judges, and we're not going to make decisions for you. I'd like to go over a few ground rules just to keep our conversation productive in light of that. Please let each other speak without interruption. It's normal to hear things you may feel difficult or that you may not agree with. If something does feel difficult to hear, jot it down and we'll make sure everyone has the chance to respond when it's their turn. And if anyone needs a break at any time, just let us know. And we ask to please keep your phone muted when somebody else is speaking. Reiterating that mediation is confidential. What's said in this room will stay in this room. At times, we may suggest a caucus, which is when we meet with one party privately for a few minutes to clarify something or explore a sensitive issue. Anything shared during a caucus will be confidential unless you give us permission to share it. As my co-mediator mentioned, we will be taking notes, so please apologies in advance if you see our head looking down. And if we interrupt at any point, please know it's to help keep the conversation moving in a constructive direction. Today is about shifting from positions to possibilities, about listening, negotiating, and finding a meeting point that feels fair, realistic, and sustainable. No one leaves with everything they want, but our hope is that you leave with something that feels workable and meaningful. We invite you to listen with openness and flexibility, and to look for opportunities to meet in the middle that protects the business reputation, keeps clarity, and brings closure so everyone can move forward. So I'd like to pass it back to my co-mediator, Kylie, to set the agenda.
Thank you so much, Ms. Haley. Do we have any questions about the process of mediation that we will be following today?
None from our side.
Okay, I think it would be more fruitful for us to hear from both the sides, your perspective on the situation, if that's all right with both the parties, and then we can proceed to set the agenda based on those talking points.
Sure.
All right. So, Ms. Rao, would you like to begin sharing your perspective on the situation?
Sure. Thank you so much, Kyle. Good evening, everyone. My name is Dr. Meera Rao, and I'm joined today with my counsel, Christo. I want to begin by thanking Kylie and Haley for bringing us together and for laying down the ground rules so vividly. I must say, your emphasis on confidentiality has really reassured both me and Christo. And I'm sure that this sentiment is shared on Jonathan's side as well. I would also like to thank you for being here today, Jonathan. I know that it takes willingness and a lot of courage for both of us to step away from litigation and attempt a cooperative process through this mediation. I still remember when you and I first met over a decade ago. And what started as a partnership of shared ambition grew into a marriage built on trust, creativity, and the dream of building something lasting together. Rao Blake Designs was not only a company we co-founded in Dubai, it was the product of that shared vision. Where I brought in design experience, sourcing networks, and a significant portion of the seed capital, and you, of course, contributed with your operational and financial expertise. And for years, we worked side by side, often blurring the line between our professional and personal lives. And together, we turned a small startup into a respected international textiles brand. Unfortunately, as tensions developed in our marriage, those blurred lines became fault lines. What had once been our joint strength in our ability to combine creative and managerial perspectives turned into division. And now we find ourselves not only navigating the end of a marriage, but also the governance of a company that supports employees, suppliers, and most importantly to us, a brand that we both still care about deeply. My foremost concern today is preservation of fairness, preservation of reputation, and most importantly, of the business itself. I fear that if we allow multiple proceedings in Delhi, Dubai, and the UK to continue unchecked, the costs, whether those be financial, emotional, or reputational, they'll consume the very value we are both trying to protect. Rao Blake's goodwill has taken years to build, and a prolonged legal conflict could unravel it in months. From my perspective, three things matter most. First, transparency and accountability. I need clarity on the recent transfers from the Dubai accounts to Blake Holdco and on the redirection of contracts. I want it to be very clear that this is not about blame. It is about understanding. Because I believe that a transparent picture of Rao Blake's finances is essential before either of us can make responsible decisions for its future. Secondly, fair recognition of contribution. While your leadership on the business side has always been vital, my design work, sourcing relationships, and intellectual property were also equally integral. Therefore, I am seeking a division that reflects both financial and non-financial contributions. One that recognizes that this enterprise grew from both of our joint efforts and shared sacrifice. Lastly, I want to focus on stability and continuity. Beyond ownership percentages, I want Rao Blake to survive and thrive. To me, that means finding a workable management structure during this transition, one that protects daily operations, employees, and clients, while also allowing both of us to move forward personally. Again, I want it to be clear, Jonathan, I'm not here to strip you of your achievements or to question your competence. I completely respect what you've built, and I understand the pressures you might face. Therefore, what I hope we can achieve through mediation is a structured and fair exit path, one that avoids a zero sum battle, ensures each of us receives the equitable value, and preserves the brand's credibility in all markets. Ultimately, this mediation is not about relitigating the past. It's about shaping a future that allows both of us and the company we created to stand on stable ground. Therefore, I come to this table in good faith, ready to listen, ready to clarify, and ready to craft practical solutions. You know, you and I, we've spent years turning creative ideas into tangible products. And I believe we can apply that same creativity here to design a settlement that honors what we built together, respects our individual contributions, and allows Rao Blake Designs to remain a name we are both proud of. I think with that said, I'll just let Christo add a few things. Thank you so much.
Thank you, Meera. So, hello everyone. It's evening here in India, so good evening from our side. For the sake of repeating myself, my name is Christo and I'm appearing on behalf of Meera in a counsel's capacity for today's session. At the outset, I would like to thank the mediators, Ms. Kylie and Ms. Haley, for facilitating this session and explaining the entire process in general, especially using the analogy of that we are on the both sides of bridge. I think it's quite apt for our current situation. I'd also like to extend my thanks to Mr. Jonathan and his learned friend for appearing on behalf of him in today's mediation session and for accepting our request for mediation. Before proceeding, I'd like to clarify my role here. I'm here in advisory capacity. The decisions and perspectives today will be Mira's own. My role is to simply assist her in navigating this process constructively and to ensure that any solution we reach is practical for the short term and durable enough for the long term. So I would like to delve into some background information surrounding the session, especially since the mediators are also here. As we all know, Meera and Jonathan married in 2017 after several years, and over the course of their partnership, they built not only personal relationship, but also a thriving business, Rao Blake Designs FZE, established in Dubai in 2018 with their major operations in India as well. Both contributed significantly to this. Meera through her creative and sourcing expertise with financial output of about 60% of the company, and Jonathan through operational leadership and a financial contribution of 40%, just like how Meera has clearly explained in the opening statements. Unfortunately, as with many dual career partnerships, both personal and professional, certain differences has caused strain on this personal and professional relationship, leading to the current dispute surrounding the ownership, control, and valuation of their joint business. The jurisdiction overlap now arising between proceedings in Delhi, Dubai, and potentially UK are some of the things we need to consider in today's discussion. While I'm confident in our legal position, if this matter were to continue to litigation, Mira also recognizes that parallel proceedings across multiple jurisdictions could drain substantial resources, damage the hard-earned reputation of Rao-Blake Designs, and erode the goodwill they have both worked years to build. This is a belief that I also share, which is why I advised Mira and suggested mediation session in the first place. That is precisely why Mira has chosen to come to mediation today to seek an amicable solution, a structured resolution that protects both her interest and the company's continuity. With that said, I'd like to briefly outline the key areas that we would like to discuss in today's session in a clearer format, because of course, this is a mediation session. Mediators, please need to take note of this. We would like to discuss this preferably in this order. First, the ownership and valuation of Rao Blake of Mira in the company. Second, Mira's roles or involvement in the company moving forward. We understand that these issues may overlap during the discussion since they are in a way interconnected. We hope the mediators can guide us when this happens so that we can have a streamlined and smooth discussion moving forward. Finally, I would just like to add that Mira approaches this table with openness and sincerity. And we sincerely hope that Mr. Jonathan does the same. She acknowledges Jonathan's efforts in building this company. And we hope that through dialogue, both can arrive at a solution that safeguards not only their personal dignity, but also the brand they created together. So that's it from our side. We would love to hear from you, Jonathan.
Thank you, Christo. Thank you, Mira. Thank you, Haley and Kylie, for having us today. Once again, warm greetings. I'm Jonathan. Please feel free to call me Jonathan. I hope you all are in good health. I hope to have met you guys in person today, which would have made our conversation much more open, transparent, and maybe a bit easier. However, I'm sure and I'm positive that we will be able to work out our differences today and focus on our future. I sincerely thank Haley and Kylie for explaining the process of mediation to us so well in such a structured manner. Because personally speaking, it's my first time being a part of such a process, and it could be confusing me for a few times maybe. So I'm sure that the mediators and my counsel Nilay will be in a better position to guide me through it. I do believe that mediation will give us the kind of flexibility and mutual understanding that litigation might not serve. In court, we might be able to defend our legal rights, but in mediation, we can protect what actually matters. I think Mira said that in her opening remarks. And we will be able to protect our business, our reputation, and the respect which we have between the two of us. Mira, I know this is not an easy moment for either of us, and I truly appreciate us coming here and having a collaborative and open mind today. We built something which was much more than our marriage. We built a company, Rao Blake Designs, from scratch in Dubai. It was a product of our shared vision, working for late nights and years of teamwork. But somewhere along the way, as you mentioned rightly again, that our personal relationship began to blur the lines between our professional aspect as well. That's where the challenges actually began to happen. For me, this mediation is not about winning any control or proving any fault in either of our cases. It's about protecting what we built together, the business, the brand, and the trust of our customers. I want Rao Blake to survive not as a battlefield, but as a legacy of what we once built beautifully together. I'm open to finding a fair and much more transparent, respectful manner of moving forward, one which allows us to have peace, closure, and professional dignity. Because at the end of the day, success for me would not be in outmaneuvering Mira. It would be in ensuring that both of us walk away with our dignity and our creation still standing. This is my purpose and hope for today's mediation session. I do not wish to assign any blame, but just to have a solution-oriented approach for today. My counsel Nilay will be in a much better position to highlight my concerns and provide my perspectives on the agenda for today's session. I do look forward to a fruitful session having an open mediation today. Thank you so much for having us. Nilay, over to you.
Thank you, Jonathan. As introduced earlier, my name is Nilay. I would like to greet everyone present here today. I have the privilege of representing Mr. Jonathan Blake in a pure advisory capacity. My role here today is to help him in an advisory capacity to express his position with clarity, to ensure that his interests are protected, and most importantly, to support a constructive as well as respectful dialogue between the parties. We're not here to inflame the conflicts that have been happening, but to find solutions that work for both the sides. In the beginning, I would like to thank our mediators, Haley and Kylie, to facilitate this process, acknowledge Dr. Rao and my colleague or counsel for engaging in mediation. My client and I truly appreciate this opportunity and recognize that mediation is a far more constructive path than lengthy litigation across multiple jurisdictions and this is a path that will save time, energy, as well as the legacy that they build together. The legacy that we all have been talking about is Rao Blake Designs. Since 2018, it has grown not just from an idea to a brand which is internationally recognized. My client is of the view that this company's success is something that is worth protecting. Whatever happens at a personal level, he believes that the business must remain stable for the security of its employees, the confidence of his associates, and the reputation of the company itself. From his perspective, the company has always been a commercial venture that has been governed by its own framework and not a matrimonial asset which is meant to be divided. He has served as its CEO as well as business head from the first day, managing operations, finances, exports, and supplier contracts. His recent actions were, in his own view, aimed at ensuring regulatory compliance and business continuity rather than concealment. That being said, I, on my behalf of my client, state that we do not wish to prolong this conflict any longer. He deeply respects Dr. Rao's creative contributions and wants to see both of them move forward in a respectful manner, maintaining not just their professional reputations but the goodwill of the company as well. Therefore, today our focus is on separating the personal from the professional, protecting the value that they have created together, and building a clear forward-looking path that lets both of the parties move ahead with fairness and dignity. That being said, I would like to come circle back to the points of my colleagues about the agenda for today's session. I am in agreement that we must discuss in the order that he stated the agendas, not just Mira's role, but as well my client, Mr. Blake's roles in in Rao Blake Designs, the future of the company itself, and whether or not it shall be attached as a matrimonial property for the divorce proceedings or not. For the facilitation of both the parties, I would really appreciate it if the mediators would post these agendas in the chat box. Over to the
Great.
mediators.
Definitely. Thank you so much, both parties, for sharing. I think it's clear there are some strong feelings and important issues on both sides. Our goal is to help you find a way forward that addresses both of your needs. I would firstly like to say that I think I really appreciate, I'm sure Ms. Haley agrees with me as well, the amicable way in which both the parties are approaching this session. I think as of now, we are all on the same page. The proposed talking points for today have been the ownership and valuation of Rao Bank, as well as Mira, as well as Mr. Blake's role in Rao Blake Corporation, as well as the future of the company. Is this something that anything else that anyone would like to add? Ms. Haley?
No, this is good.
Yeah, this seems fair. I think it covers both of our
All
parts.
right. So we can keep adding to our agenda as the session moves on. And if we do not complete our issues by the end of the session, please note that we can always schedule another session. Our goal today is to lay the foundation for a future that we can build together. So we can go ahead and start with the first issue, if that's all right.
Right. Jonathan, I think, thank you so much, Ms. Mediator, for giving me the floor. I think, Jonathan, we've gone over this a lot. Like, we've had a lot of back and forth with this in this regard as to what we need, what our visions are with regards to the company. And again, I really thank I think your counsel for laying down your position so vividly. But could you just elaborate as to what your vision of the company is? Would that be one wherein we both together have shared ownership over the company? And again, with regards to control as well, would that be an arrangement wherein we both have control over the company, or would you rather have one where one of us be the sole owner and then consequently the sole controller of the company?
So Meera, just to answer your question, I just want to understand the question first. So it primarily revolves around how the ownership of the company will proceed, correct?
Right. I'm just again, just to simplify the question down, would you be
Yeah.
willing for going for a shared ownership or one where it's sole ownership for either of us?
Um,
The sole ownership would entail that one party would have to receive a buyout of their ownership stake and move over to the company. Just to clarify.
All right. Thank you
all
so much.
right. Okay. Thank you, Krista, for that. Thank you, Meera. I think what we were considering clarifying initially in the session for today was something with respect to the valuation. However, in terms of your question, something which is preferred to me and just wanted to lay down, as Nila also mentioned in his opening remarks, that our company is solely an independent entity. It is not one of the matrimonial assets which we have. Just laying down as that being my perspective in this matter. I prefer having this consequently the sole ownership of the company entirely. I think Nilay will be in a better position to break this point down for you. Nilay?
Thank you, Jonathan, for putting forth your point. To elaborate on what my client just said, as we all know, his intention has been to keep the company far away from the divorce proceeding, in the regards that it not be its assets or the company itself not be attached as matrimonial property during the proceedings. For this same, he would like to maintain the status of a company as an independent asset and not one that is owned by either of them completely. So until the pendency of the divorce proceedings, he would like to keep the company away from these proceedings and would like Dr. Rao to not attach them. To that effect, we are ready to offer compensation to in the form of a buyout to Dr. Rao as to giving up her stake in the company after the proceedings are over, because until the pendency of these proceedings, if it is completely owned by either one of them, we would circle back to square one, where it would end up becoming either a shared asset or being liquidated and the proceeds being split between them, which is definitely not our potential that has our intention that has been highlighted by me and my client earlier. So before shedding further light, I would like to know from Dr. Rao or my learned colleague if we're on the same page so far.
Again, I do understand that there are irreconcilable differences between us, but at least the approach that me and Christo went over before the discussion would be one wherein we'd want a shared ownership and again, consequently, a shared control over the company. But again, while I do understand that you want a buyout, I think that is something I can discuss later. But again, before we delve deeper into that, I do have some concerns because at the end of the day, this is a company that we've both made, and the last thing I'd want to see is for the company to go down or just have any harm caused to it or any losses. So again, speaking of the same, I understand that most of the supplier contracts that our company has for the production of textile are circled through my own company, which is MR Sourcing, I'm really sorry. So given that, given a situation wherein I would be bought out, and again, that would imply that MR Sourcing and the sort of arrangement that we have between MR Sourcing and our company, that would also be gone. Is that something that you personally, Jonathan, have some plans to mitigate against, or is that just something that if you could just shed some light on the same?
Just to streamline the entire question, what Meera is asking is that since MR sourcing has been always the major sourcing material from India and is 100% completely owned by Meera herself, and the proceeding which Meera's expertise and core designs also has contributed from Meera's side itself, is there any plans to mitigate these challenges if the potential buyout happens in the future?
All right. So just to answer your question, that is something which is contingent on a lot of factors, because right now we're still discussing as to how the ownership will actually be shared. In terms of that, I just wanted to ask one simple question, if you could clarify before I move on to my answer. What kind of shared arrangement are you looking at?
So again, with regards to the shared arrangement that I was talking about earlier, if I may just elucidate on the same, it would be wherein, again, a similar situation like earlier, wherein both of us would have a fixed share. Again, the like the modalities are the same. I think can be discussed just in a short while. But in addition to just having shared ownership, it would also mean shared control over the company. So again, if I may just circle back as to how it was in the past, wherein certain sectors like supplier negotiations and product design would be things that would be under my purview, things that I had control, and then other things like operational and financial expertise that I mentioned earlier as well, those would be under your purview. That is roughly the shared arrangement that I had in mind when I was proposing the same.
Okay, thank you for that clarification. Haley, is there something you want to add?
No, I just wanted to quickly bring us together and highlight what's been discussed so far to make sure that we keep the conversation productive and moving forward, which I think everyone's collaborating so well together so far. It looks to be that Jonathan's proposing to, I'm sorry, it looks like Dr. Mir is proposing to have sole ownership of the company and would like to proceed with the company as an independent asset and keep it away from further proceedings, and is willing to offer a buyout after these proceedings are over. And then in turn, it looks like Jonathan has a preference for keeping the company with both of you and each of you having a fixed share in the company as well as shared control over the company in the respective roles that you already have. So just laying that out quickly, in the spirit of working together to find a resolution. I just want to make sure that the responses are geared towards seeing, how we're feeling about those propositions and if there's any room to meet in the middle.
Just to clarify one point, I think I was proposing for a buyout and a sole ownership, and Mira was the one who wanted to have a shared ownership. I think the names just got confused. That's completely fine.
Thank you.
Just as a clarificatory question, Mr. Jonathan, would you like to discuss the stake that each of Mira and Jonathan will own in the company in general? I mean, the determination of stakes is important for either of the questions, whether it is a buyout or whether we proceed with a shared ownership. So how about we get onto the stakes factor first then? Is that amenable?
That would be fine with me, but just to ask one question here. The arrangement of ownership which you guys are talking about, or the stake ownership which has been talked about, is this during the divorce proceedings, after the divorce proceedings? What kind of timeline are you looking at here?
So I think given that you guys you Jonathan, you don't want it to be, again, I would love to clarification on this again, also before I proceed further. But given that you wouldn't want it to be treated as a matrimonial asset and then again subsequently have an equal 50-50 split on the company itself, would that entail essentially us going forward with the same 60-40 split that we originally had with the company, with regards to me having the 60% stake and you having the 40%? Or is that something that you'd want to be amended? If I could just understand the same before we proceed further on.
Sure. So just to clarify on that, it will be preferable for me and amenable to me that we change our arrangement a bit. All of this is quite contingent on how we're looking at the company at. In order to provide a much more clarity in terms of the buyout, which we were talking about earlier, and Nilay provided some light on that, I'll just share very briefly as to what we meant with that. What we actually meant was, after the divorce proceedings have been concluded and we are done with those proceedings, I buy out Mira's share for an amount of $1 lakh. Oh, sorry. For $1 million, I'm so sorry for that. For $1 million, we would buy out Mira's stake, and further on, after the divorce proceedings, the entire control shall lie with me, Jonathan. Nilay, do you want to put more light on that? You want to elaborate on something?
So what I've been able to understand from Dr. Rao and her counsel so far is that they're asking us our stance on determining what the current situation is between us as to how much stake do we currently own, and then discuss the future as to what course of action do we want to follow for the future. With that regards, I think I would have to pass it back to Jonathan to explain, as he's been in charge of handling the business of the company, as to how much percentage or what value he holds Dr. Rao's stake at. But as he's already stated, we have put forth an offer of buying out Dr. Mira's stake that he will explain at an offer of 1 million US dollars. Further, about the course of action and the buyout that's been talked about, I just want to put some clarity on my client's favor, on my client's part, is that whatever arrangement we come for right now, determining how much stake we have right now, is for the on a tentative basis, for clarity as to what understanding we have until these proceedings are over. However, as soon as these proceedings are over, uh, for whatever alleged sum Dr. Rao would have supposedly received if this were attached as a matrimonial property during the proceedings, to compensate that supposed amount that she was supposed to receive, we have made the offer of the buyout. Therefore, we will be compensating her of the division of the assets. And then in the end, we will also retain the company itself, because that's our own ambition. So she receives her adequate compensation. She is set off for her claim. And we keep the company, which we feel is amicable to both the parties, since at the end of it, if the company's assets were to be attached, they were going to be liquidated, or if they were cash assets. I personally am not allowed or authorized to share much, but Jonathan has knowledge himself about it. uh, it would just end up in a situation where we would end up with money, but what we consider this company as is a bigger perspective, and hence our offer. Before I
Right.
pass it over.
Yeah,
No.
thank you
Sorry,
so
I
much.
just had a
Before-
clarificatory question.
Yeah, please go ahead. Mr.
Clarificatory question. Yeah, thank you. For clarificatory question regarding this, from what I understand, there's a 1 million offer on board, right? 1 million offer. Can you tell me how you arrived at this number? And if possible, can you tell me how much this 1 million would be constitute as a percentage in the total company's share? And also, if you are considering 1 million as a percentage, what was the total company valuation that was put forward there?
To that end, I feel like I said before, Jonathan is the better person to explain. Even though I am his counsel, he has the authority to explain the monetary valuation of the company. So I would like to pass the baton to Jonathan for a better explanation.
Yeah. Thank you, Nilay. And just to mention one line first, Mira, the proposal of us initiating a buyout for you after the divorce proceedings is truly not something which we mean as not acknowledging your contributions to the company at all. So please don't take it otherwise. We truly acknowledge and appreciate all the efforts and the designing work you've put forward in our company, which we built together. So I do not mean it in any other way possible. So please do not take it otherwise. I'm sorry, I should have clarified this a lot before why proposing, which just coming to this. The valuation of actually 1 million was derived at because we value a company at $2.6 million. Given our present split of 60-40, wherein Mira has 60% of stake and I have 40% of stake, 40% of that would roughly come to $1 million. Now, recognizing that as something which is currently being discussed, and as Nilay very well said, that after the divorce proceedings, this will be a sum which will be compensatory in nature, meaning that a sum which will be derived from our company in terms of Mira's 60% stake would already be compensated after the divorce proceedings have been concluded. That is how we came to this number. Nila, do you want to elaborate on something with respect to this?
I think this
If I may just
Oh, please go ahead, Mr.
sorry, if I may just interject, Mr. Jonathan, what you are saying here is that the buyout will happen after the divorce proceedings. Am I right? Is there anything that we have to say for what will happen during the divorce proceedings, or is this just contingent to after the divorce proceedings are completed?
Since this is a procedural question, I feel the answer to this is a procedural answer, is that the tentative arrangement that we are to follow for the time being of the pendency of the proceedings is one of the agendas, if I'm not wrong. So we rather Yeah.
Definitely, we can continue this conversation at another time. I just wanted to put this question out there.
Yes, yes. We are mindful of this. We have our own propositions in that regard as well, and we would like to hear Mira's thoughts. But tentatively, yes. And to answer the question put forth earlier, is to not the another question, but what Jonathan asked me to clarify here is that we currently, on behalf of my client, I would like to state that we value our contribution at not less than 55% of the company at the moment and 45% to Dr. Rao. To that end, we roughly hold the valuation of the company, as she said, as he said, at 2.6 million US dollars. And to that end, for her capital that she has invested and her contributions, her IP, we're offering the compensation. As I clarified earlier, she would be eligible to, both the parties would be eligible to receive a certain sum at the end of the divorce proceedings. This compensatory amount does not mean that we want to kick her out of the company. It's just that we want to make the outcome of these proceedings better, because we know litigation, uh, there is a chance that they might take our interests into consideration, but they will follow a way stricter approach than what we can work out right now. As far as retaining the role is concerned, I believe if these proceedings, and I hope that they end fruitfully, we can retain Mira. It's just a possibility that I'm putting out there to reassure Dr. Rao, by the authority placed in me by Jonathan, that we can consider keeping her as a consultant for the design contribution that she's been making. And with regards to the supplier contracts that were being talked about, we feel that it's a it is currently a little bit out of the scope of being discussed, because that's a completely privately owned a corporation by Mira herself. The supplier contract would actually be conditional to the competitive pricing or the industrial standards that Jonathan later can determine, since he is the one making decisions regarding that.
Right.
Um,
Thank you so much for the clarification. I really appreciate it, Nile. And again, if I may just, I know there's been a lot of numbers set on the table. So if I can just address all of them at one, like one by one. Firstly, with regards to the stake, the percentage stake assigned to me with regards to me being 45% and Jonathan having 55%. Is that also, again, I heard I think it was said by Nilay himself that this also accounted for the fact that I have at least some role in design. But given that I also have the core IP for the entire design of all our products, I also, in addition, like you mentioned, I have an active role in design. And like I mentioned, the supplier contracts that we have coming in from India and a lot of other countries, all of those are contingent on all of them are sourced through my own company, that being MR sourcing. So are all of these contributions being accounted for when giving me this, assigning me this 45% stake, is something that I just wanted to confirm. If I can just get an answer to this, and then I can proceed to my other concerns as well.
Mira, yes, I would just like to answer that question. Um, all of these things have been taken into consideration while offering that. As I did mention, that it will only be happening post our divorce proceedings. I do feel here right now we are going around in circles and throwing in a lot of information. So I just wanted to know as to what your actual stance is here,
I'm
because I
very
feel
sorry
there's a
to, but since there is a little bit of confusion going around and quite difficulty in getting to an agreement, a slight difficulty, I think a private caucus would be quite apt right now, if that is amenable.
I agree with you that we do need a caucus for this impasse. However, just like my client Johnson just stated, before we discuss with the mediators as to how we go forward, we would like to know what your state of mind is regarding all the parameters that we've offered so far, as to this is what we hold the company as valuation at, and what we value, how much percentage contribution we value your stake at. If we could just know what you feel about it, then it would help us uh, understand better as to what we can work on our offer to make, to address your concerns and to pacify them.
Again, I think just to clarify my position, while the idea of having me bought out and no longer be a part of this company that I built was something I initially was apprehensive of. I understand that the differences between us have led us here. And again, while I'm not completely against the buyout, I think the specific terms that have been offered, those being the stake, the percentage stake that I've been assigned, as well as the total valuation of the company, I do believe that there are, I'd say, some differences in both of our positions in that regard. And I think a private caucus, as Christo really aptly put it, can help us sort of come closer with the help of the mediators, of course. So I think if we can discuss the same in the private caucus as well, that'd be really, I think,
I
fruitful.
just
I
had a
completely agree.
just
Sorry,
had a
please
very small
go ahead.
question to ask. I will not take more than 30 seconds. Meera, I just wanted to ask, you spoke about there being some differences with respect to the valuation and your stake in terms of the company. Can I roughly know as to what picture are you looking at? Because in the private caucus, it will be much more easier for me to discuss with both Nilay and the mediators today as to how we can proceed, because I don't wish to continue circling like this any longer. So just very briefly, just shed some light as to what valuation are you looking at and what stake are you looking at?
Right. So I think right just before coming out of this table, we actually, me and Christo, we consulted an independent auditor, someone who gave us a specific valuation of the company, and what we came at was a total of 5.2 million US dollars for the company itself. And again, my stake being adjusted to according to the same, this is the figure that our auditor came to. But I think once we're done with the caucuses, with our own respective caucuses, we can discuss the same and sort of close down on our positions as well.
So just before we go to the caucus, I would just to clarify this caucus, this amount that is 5.2 million in total was evaluated based on the assets, liabilities, and future prospects of the company. These were the major factors, and also the goodwill that the company owns now. These are the four major factors that was considered while determining this figure. So I think we can proceed to the caucus, or is there anything Mr. Jonathan wishes to know?
No, I just wanted to clarify that this was as per an independent auditor which you all had to.
Yes. An independent accountant had taken care of the valuation, and this is the figure that he had given as well.
5.2 million, right?
Right.
All right. Thank you, sir. That was it.
Great. Thank you all so much. It looks like we have some numbers to think about. I wanted to ask if either of you have a preference in the order in which we proceed into the caucus. I want to make sure that we're honoring both of you, or if you would like us to choose.
I believe that since Christo has proposed this caucus, we'll rather let them make it clear to you as to what their stance is, and then you help us understand what it is, and we can maybe rework whatever has happened so far or what we want to do for the future. So
That works.
we'd like to go second.
Absolutely appreciate that. Yes, just wanted to make sure that I was giving everybody space in case there was anything pressing that came up between. So we will take a few minutes to discuss and then switch over. Thank you.
Mr. Jonathan, Mr. Nilay, if you could please lead the meeting.
I believe we need a breakout room because we leave the meeting. Yeah. Okay.
Oh,
Yeah,
right,
that's
this is the
fine.
meeting. Right. Organizer, if you could just help us with this, please.
Great. Great. Thank you so much. And I really hear what you guys are saying with your concerns in terms of making sure that the valuation is based off of, the third party coming in and making an unbiased assessment, and wanting to make sure that you're cooperating in a way that keeps the reputation of the business at the forefront. And so we hear that, you had the auditor reach the 5.2 million value of the company based on the assets, liabilities, and future prospects of the company. I know that we've been discussing the potential of a buyout, but it might be, you have expressed that you may prefer not to be bought out. I wanted to gauge a little bit more about that. And, if a buyout is something that you are open and flexible on, or if you have more hard limits and would prefer to have more of that stake in the company moving forward, and what that would look like, just to understand, how we can proceed in mutual like working together and moving forward?
Right. I think before I go any further, I just like to correct myself for a slip of tongue. It wasn't. I think instead of saying independent, instead of saying an internal accountant, I accidentally said independent. So just to clarify, it was my own internal accountant that gave us the estimated valuation of 5.2 million. And again, just to clarify my position on the same, while as I mentioned earlier, this is a company that I and Jonathan both have built up from the ground. So while my initial aspirations were to continue on this role, make this, scale this to an even bigger to be in a even bigger company, I do understand that because there are such differences between us at the moment, that might not be possible based on what Jonathan said. So again, while a buyout wasn't something that I initially wanted or prioritized, it is something that I can accept given that the terms of the buyout are something somewhat fair.
Okay.
And yeah.
That's fantastic. And I love hearing that you're able to be flexible in the pursuit of really keeping, what's best for the fruition of your company. So given that you are open to a buyout, depending on what those terms are, would you be able to lay out what would be the most ideal for you?
Right. So when I came onto this table, I think after a lot of discussion with my accountant himself and Christo, we ascertained roughly a figure of, I think, a 50-50 split between the company because, from what I understand, although we had a 60-40 split when we first started in the company, I do understand that Jonathan has come to sort of hold a more central position with regards to the administration and the control of the company. But what I also want to acknowledge is the fact that I myself have contributed substantially with regards to the designing and as I mentioned earlier, the supplier contracts, all of those negotiations. So what I want today is an equitable solution that also takes into account my contributions to the company. So ideally, that would be a 50-50 split. But given that if he may agree on a valuation that is suitable to us, I may be able to bring that down to 45%. But then again, that would be contingent on him giving us a fair valuation because I think 2.6 million at the moment isn't something that reflects how valuable the company is, at least from a financial perspective. And
Just
also, again, just
Just
before
to
I let you speak, Miss Mediate, I'm so sorry. But also, I think if my error that I made, the error with regards to there being it being my internal accountant, not an independent accountant, if that also maybe just cleared up in the joint session once the private caucuses are over.
Just to clarify, the 50-50 split that you are referring to is based on your valuation of 5.2 million, right?
yes.
Right.
Or would it be based on any other valuation, depending on what
No,
is agreed
Again,
to?
the 5.2 million
5.2 million is something that at the moment it is something that we are at. But again, given that there are such a drastic difference in our position, there is something that would be amenable to at least lowering down a little. But then again, I think just to reiterate what I said earlier, I think 2.6 is a figure that's too low. So before I had agreed to lowering down that valuation down, I would at least I would want at least some sort of guarantee that the total amount that I'd be getting through the buyout would be something that's equitable.
All right, but you are quite firm on your stance of um, acquiring 50% split. Am I correct?
So just to clarify,
Or
we are quite firm on 50%. That will amount to about $2.6 million according to a 5.2 million valuation. But we will also have to hear what they part and whether they consider the contributions put forward by Mira on considering to lowering down this amount. That is what my client said.
Thank
Also,
you so much.
please go ahead, Ms. Mediator.
No, thank you for providing that. So I know that there are other factors that might be impactful in this. I wanted to ask if there's any other, factors or topics that you wanted to touch on that might also make an impact on this so that we can go back into the conversations, keeping those in mind, and moving the conversation forward.
Right. Thank you so much, Ms. Mediator, for that. Again, if I may just elucidate on the same, I think with regards to the two factors, there are a few actually. If I may just classify them as to into one category that sort of is concerned with my own interests and one that is concerned with the company's interests. And this is something I wanted to bring up in the joint session as well, but I wasn't able to given that there was a lot of back and forth. But my earlier concern with regards to supplier contracts, recently, I think just a few weeks ago, I got word from two of our key Indian suppliers that I think amount to upwards of 700,000 USD of the total value that they bring to the company, which is again, given the valuation of 2.6 million, that's a large percentage of our company's valuation that they bring to the table. And given that the recent dealings from Jonathan's side through Blake Holdco, those dealings have made them apprehensive of, continuing relations with Rao Blake. And given that further, future unilateral dealings in the manner that Jonathan has been carrying them out, given that that would again jeopardize the entire company's interest as one, that is something that I would want divulged to Jonathan as well. And again, just with regards to my own personal interest that I mentioned earlier, my insistence on having an equitable buyout has more to do with the fact that at the moment, and I'm divulging this to the mediators just so that you can understand where I'm coming from a little better. But at the moment, I'm with regards to how many assets I have, I don't have a lot of liquid assets. I think based on what my accountant said, I have roughly 26, 27 lakhs in INR, which amounts to, if I'm not wrong, please do correct me if I'm wrong, Christo, amounts to about 35,000 US dollars. So that is, again, something that I'd want to mitigate through the buyout, and is exactly why I'm looking for that equitable and fair buyout that I keep going back and back to.
So the one thing that needs to be considered when we are putting forward, when they are considering an amount, is the fact that two Indian suppliers, like Meera just said, two Indian suppliers that is worth $700,000 has warned they will terminate their supply if there is if there is instability in the company. That's one thing that needs to be considered. Another thing is we have insistence on obtaining this buyout in liquid assets if possible. Is there anything else? I'm sorry.
No, thank you for clarifying. So I just want to make sure that while we enter the conversation with them following this, confirming that we won't be discussing your personal financial situation. We'll keep that confidential. We can share with them that we'll clarify that the valuation was not done by an independent accountant, but your personal accountant, to make sure that you're being transparent, and would like the 50-50 split based on that 5.2 million valuation. Would you like us to provide any other of those details, or see how they react to that first and then what they have to counteroffer before
Are you
continuing?
comfortable with us mentioning the 700,000 US dollars that would be pulled out by the suppliers? Is that something you're comfortable with us mentioning?
Right. I think the majority of the information that I did mention in the caucus, I would want that divulged to him just so that he also gets a better understanding from where I come from. But then again, I think as Haley rightly mentioned, I wouldn't want the information with regards to me having a lack of liquid assets to be divulged to Jonathan. I think besides that,
Definitely.
anything else I would appreciate it if that would be divulged whenever the mediators deem necessary.
Great. So if there isn't anything else that you'd like to flag, we'll go ahead and we'll do a little switch and chat with them, get the reaction, and then come back together in conference.
Right.
Thank you.
Right. Thank you so much, mediators.
Thank you.
Yes, welcome back to the session. So, is there anything else that you'd want us to understand about your perspective that maybe hasn't come across yet, that you'd want to bring to light?
Yeah, actually, there are a couple of things which we wanted to share with you in a much more structured manner. Before that, can I just know, is there a particular time which is allotted for each caucus so we can be mindful of that?
So I think Miss Haley, please correct me if I'm wrong. We like to limit it to around 5 minutes, if that's possible. But if we are in discussion, we'd allow the session to continue.
Thank you so much. Coming to the first point, which is with respect to the valuation which we had arrived at. So just to reiterate, the valuation which we were looking at was 2.6 million. Just to provide a rationale to this, there were a few clients which were lost, which the company itself had lost, and that is why the valuation was derived at a number which was less than $5 million. I think approximately $5 million was the number which they had proposed as a valuation to us. So that was a whole rationale of coming to the $1 million buyout and the 2.6 million valuation. Taking into consideration the clients which were lost and the future prospects of the company, that was the sole reason as to how we came to that valuation. The second point being, in terms of the buyout, which when we proposed that we would be willing to pay $1 million in exchange for buying Mira's stake out of the company, one thing which was contingent on this was her dropping of the marital claim. We don't mind raising this number to $1.2 million, provided that we end the divorce proceedings altogether. She drops charges with respect to the divorce proceedings. And then I think she also has a stake in the she also has a compensatory amount which is there. And I have the sole ownership of the company. And just to say that this is with no intention of not acknowledging the contributions, because with respect to the 55% ownership that we seek to have and coming at their stake thereby being 45%, the whole rationale was this, acknowledging her contributions to the company, because both of us build the company together. Coming to
Mr. Blake, sorry to interrupt. Could you just repeat the amount that you'd be willing to go up to?
it was 1.2 million points.
All right. So 1.2 million contingent on the dropping of the marital claim, right?
Yes, correct. And I believe that there was a lot of back and forth in our joint discussion with respect to what the temporary arrangement would look like in case we will be buying her out after the divorce proceedings. I believe that is something which we've cleared the air on, that if we wish to raise the amount as compensation to her in terms of her dropping off the divorce allegations against us. In terms of temporary arrangement, we were looking at the initial split, which is there temporarily. That means in the present few weeks, that the stakes between the two of us will be divided in the same manner as they already are, which is 60 to 40, 60% being with Mira and 40% being with us. However, something which was truly disheartening, and I felt that I should not disclose this in our joint session with Mira, was that there were certain allegations about siphoning of assets from Mira's side. That was something which was truly disheartening for me, and I did not wish to, divert our conversation into a manner wherein it was not. We are okay with having the current present 60-40 split, taking into consideration the present stability of our company, because we do not want the company to be affected at all in terms of how things are in our personal relationship. So we're okay with having a 60-40 split, but that being contingent on the fact that she drops off the allegations with respect to siphoning of asset. The 60-40 split will only be there till the year of March 2026, which is, I think, approximately 6 months from now. So just to reiterate and giving this in a very brief manner, I'm sure Nilay will shed more light on this. However, we are looking at a present temporary solution of a 60-40 split, the temporary solution being till March 2026, contingent solely on the fact that she drops off the siphoning of assets allegations, which was made. Post that, I will resume the sole control of our company, which is post March 2026. I think the will be in a better position to give this in a structured manner, I believe.
Just to clarify, so this 60-40 split, that's a temporary solution which will cease to exist after the buyout. Is that right? After the divorce proceedings are dropped?
Yeah.
All right. I also just want to disclose something that Miss Mira has shared with us. I think there was a little bit of miscommunication here. She had mentioned that the valuation was done by an external accountant. She had actually meant an internal, a person who had valued the company internally. So that's just something that we wanted to clear the air on. As well as she has also proposed her terms of buyout, which she has requested it to be a 50-50% split. according to her valuation, which was a $5.2 million valuation. That would mean $2.6 million per person. This is something that we can discuss again in the joint session. I just wanted to put this out there.
Thank you for that. I just wanted to understand the question that I asked you a bit earlier. I think
Uh,
like to the 60-40 split, that being
yes.
after the divorce proceedings or before the divorce proceedings?
Oh, right. I just wanted to clarify, when would the 60-40 split be terminated?
March 2026,
All
post
right.
which I will have the sole ownership.
Okay. Is there any rationale as to why it would be March 2026?
Yes, as I mentioned, that a period of 6 months from now on, having changes being done in our company right now when things are turbulent privately between the both of us is not something which we want our company to have an impact on. Having maybe a grace period, if you can say, for 6 months, wherein the proceedings, if they happen, are terminated between the two of us. So the 6 months period essentially is a grace period which we are looking at, so the stability of the company can be maintained, and there are no changes which are done which are so grave in nature that will have an impact on the company. So we don't want any immediate changes to happen. We want to have the changes. We're open to changes, but only in a
Yes.
one by one.
I just also want to clarify one last thing before we return to our joint session. I think Mr. Nilay had mentioned something about keeping Miss Meera in as a consultant at the company. I just wanted to know where that stands in this offer.
In the 60-40. I'll just shed a bit more clarity on that. What he actually meant was, if we look at this temporary solution of having a 60-40 split till the year March 2026, Miss Meera will obviously, being her part of the job, which is looking after the designing and the IP, in this particular manner. If this was contingent on whether they will be dropping of the allegations which they have raised or not. I think Nilay had actually meant that. In terms of that, we were actually looking at a picture wherein if we continue to have a 60-40 split and in the current roles which we have and not as a consultant, we will be okay with having some form of clarity with her also while making huge expenditures. For example, because our role will be 40% of our $2.6 million valuation, and I explained how we came to the $2.6 million valuation. I think $1 million, any expenditure which would be above $1 million, we will be okay with discussing that with Meera first. We will, of course, pay the signature on that because I'm the one who will be handling all of this, being as the CEO and doing the daily business
All
administration
right.
of the company.
Okay.
That is just with respect to that. I think Nilay can shed some more light on this.
Thank you, Jonathan, for putting forth our points so well. Just to elaborate a little bit, I'll begin with the most recent point that they mentioned about having a 60-40 arrangement while also keeping her in the loop whenever we're making a major transaction. We see this as a step, an initiative from our part in the spirit of compromise to keep her informed, to keep her reassured, because what has very clearly happened is that there is some mistrust between our clients, mine and Christo's clients, regarding whether we're running the company in good faith or not. So for major transactions which we value above 1 million, which is 40% that we value at roughly, we would take her we would take her into the loop for such transactions, so that she is reassured that we are not making major decisions without her approval, because those are a couple of the claims that she's made against us. Moving further, I would like to reiterate that the 60-40 arrangement will remain, because my client acknowledges the seed capital that she has made, and until these proceedings are formally over, we would like to not disturb that arrangement. As to the 55% that we said, and then the alleged 50% that they've put forth, That is what we feel is the effective arrangement as to the contributions, effective contributions to how well the company is doing between the two. The capital is one thing. Yes, initially she has invested more capital than us, but we are willing to compensate her for it. And as she rightly pointed out in the beginning, as my client rightly pointed out in the beginning, we already have raised our offer because we feel there is scope for some betterment if she has reservations. So to sum up, tentatively for the agenda that we're at right now, we'll raise our offer. However, the valuation that they've increased and the demand that they've put forth of 2.6 million, as we've already made it clear to you, that's our entire valuation of the company. So from my client's perspective, that's literally buying the entire company from her, even at the stage where he knows that he's losing clients already. So that's where we expect them to make some concessions towards us. But then that's for something for us to discuss in the open session. And then the other 2 points about maintaining the 60/40 shareholding, the capital that's been there for a period of 6 months, because after 6 months, obviously, for if this impasse lasts for a longer period, it's going to be difficult for all of us. Hilly, I
I'm
see
so
you.
sorry. I want to acknowledge that we do need to join the conference again. So I wanted to get your permission to share that after discussing, their offer, we've landed on an adjustment of a proposal of 1.2 million buyout.
Yes.
After for a continued 60/40 split that would end in 6 months, contingent on dropping the divorce claims,
Okay.
and see how they feel about that.
Just to
Uh,
clarify on one point, divorce claims meaning that they are claims over the company as a matrimonial asset.
Yeah. All right.
Yeah.
And about the 1 million reassurance, that also is something that we look for them to drop the accusations of siphoning of the assets, because that's the issue that we want to address in that regard, in order to safeguard their interests and to give them some reassurance. So there are two claims that are initially the root of this problem that we want them to drop. That's what we're here to avoid, right? The litigation that's going to go about it. We're willing to reassure them, we're willing to make concessions. Obviously, the end goal of this mediation is to avoid that litigation, and therefore we would like to imply that these charges, the two of these charges, regardless of their different nature, be dropped against my client.
And we would just like to have a discussion which is much more open, because we too are trying
Yeah.
to come to a solution, but we feel that there's some lack of information coming from their end, their
Yes.
concerns.
If it's all
So
right, we'll call the other parties back to the meeting and we can reframe our conversation. All right, welcome back to the session. I think a common theme that has been brought up by both the parties during the caucus that we have observed is the concern about stability of the company. Ms. Meera had disclosed that the suppliers were threatening to back out, which would result in losing of 700,000 US dollars in the case that there was instability. And for that, Mr. Jonathan has proposed keeping the stakes at 60-40% for the next 6 months, that's till March 2026, in order to safeguard proceedings and to maintain stability. That's the offer that's been put out on the table as of now regarding stability. Yes?
Right. So I think I do have.
Sorry,
Please.
there's a little bit more to it. It's not the full offer, so we just want to make sure that we have it all out on the table. And then we'll let you know when it's finished.
Right. Please go ahead, Ms. Mediator. I'm so sorry.
Oh, please. Kylie, if you wanted to finish, or I can step in.
Right. So Mr. Jonathan has sort of stuck to the $2.6 million valuation and has stuck to as agreed to the buyout being $1.2 million contingent on the dropping of the maritable claim. So that's the complete offer that's been laid out on the table. Is there anything that's missing?
Can I just add
Jonathan?
something just to make the offer a bit more clear for Meera as well? Talking about the 60-40 split, which we were looking at as a temporary solution in order to ensure that the stability of our company remains, that being till March 2026 onwards. I actually disclosed this to the mediators, and I would like to disclose this to you as well. That in this offer, one thing which is contingent and is not negotiable to us is that the allegations with respect to siphoning of the assets will have to be dropped, because that is something which it just shows that there is some form of mistrust between the two of us still. That being said, talking about the stability, I understand that it is important to have a 60-40 split, which is currently our split as well. So there will be no change in the stakes as such, not hampering our ability to continue performing for our company till March 2026, only being contingent that those allegations be dropped. Neil, if there's something you want to clarify further on this, please let me know.
I feel Jonathan has put them forth appropriately. It's just a step of reassurance for us. Again, circling back to what we've made a couple of other concessions that we think the mediators would be in a better position to communicate with you when we get to that part of the agenda. But I feel that since we left this conversation while discussing the first agenda, it's pertinent for us to move forward on it.
I'm sorry, but from what I can understand, there was a 40% offer for the buyout, right? 40% of your valuation, that is 2.6 million.
There's been a little bit of confusion here. I think the mediators could step in if they could step in and clarify.
Right. So I think what Mr. Jonathan is proposing is for a $1.2 million buyout that is contingent on the dropping of the maritable claim. And in order to maintain stability, what Mr. Jonathan is proposing is to maintain the 60-40 split for the next 6 months, that is till March 2026.
And okay, just to just to confirm from your side, Jonathan, as well, the 60-40 split that is being brought into question is the one that we had from the beginning, that being 60% with me and then 40% with you, right? That is from this original.
Yes, that's absolutely correct. If there's some sort of confusion, I'll just break it down in just 20 seconds. There are two things on the table right now with respect to the present situation and something which is temporary in nature. Considering that a major question which was there and we went around in circles with respect to the company being a matrimonial asset. Our initial offer was to have a 1 million 1 million buyout. However, we are willing to increase this to $1.2 million, provided the fact that the allegation with respect to the company being a matrimonial assets be dropped. This is the first aspect of what we were trying to do. The second aspect, being a temporary solution till the period of March 2026, is that we continue to have a 60-40 stake, which we currently already do, 60% with Meera and 40% with me. That will continue to stay for a period of 6 months till 2026, provided that the allegations with respect to the siphoning of assets be dropped. In addition to that, I think there was a little talk about transparency. I think, Meera, you mentioned that in your opening remarks as well with respect to transparency, with respect to the expenditure of what is happening in the company. I believe that being the CEO and having some form of control over the business administration of the company, having some form of control over the business administration of the company, we were thinking that these decisions lie with me. However, some decisions involving a much larger sum, for example, $1 million, those I will obviously be the signatory on those. However, we will definitely consult you with respect to that, only for this period. These might seem as two coinciding points, but however, these are just the two separate proposals which we had made during our private caucus with the mediators. That's why we just wanted to shed more light on that, not trying to mix the agendas at all. I would just like to hear your perspective as well on this.
Right. Thank you so much for the clarity, Jonathan. So again, if I may just address the two offers separately, right, just like you did. With regards to the offer on valuation, I believe that the total valuation you offered was that of 2.6 million, and my stake in it being 60%. But I think, if I'm not wrong, do please correct me, Christo. I'm not the best with in these cases, but I think that would amount to a value buyout of 1.56 million, given that it's a total valuation of 2.6 million with me having 60%. So I think, as opposed to 1.2, that in itself would amount to 1.56 million, if I'm not wrong. And again, so I think considering there's been a lot of back and forth, if I can also just address the second offer with regards to my continued role in the company. Again, I'm really glad that both you and Nilay, actually, who brought it up earlier, came up with this to sort of keep me involved in the company, which ultimately both of us have created. But in regards to, again, while I am very glad that you are making this concession, my concern with that entire offer is to be involved more of with it as a status of signatory. And again, I think if the mediators may have divulged to you the same, the fact that already there is a lack of stability in the company, given that we have suppliers who are worth a large chunk of our business backing out. And there's an additional actually thing that I wanted to bring up as well, specifically with regards to our credit facilities in Dubai. So I think, given that the nature, the unrest that has been going on in the company, unfortunately, that has gone public. And as a result of the same, I have been informed that a credit facility that we have based in Dubai, worth approximately 500,000 US dollars, is at the risk of being, since it's up for renewal, I think coming up soon in about 4 or 5 months, that renewal is at risk, given that there is a lack of stability. And my sort of idea, or my offer to stay connected, stay in the company as a signatory on major decision, like you just said, was in fact a direct effort to mitigate the same, because the concerns that have been put forth to me are essentially that what they want from the company is stability that directly comes from joint partnership or joint directorship. And again, I think
Miss,
I think speaking too much, I'll just love to hear your thoughts on that as well. If the mediators may summarize
sorry.
as well.
Yeah, Miss Meera, just
Yeah.
to interject here, just to make sure that we're all on the same page and to bring our conversation back to the first thing that you had said. This 1.6 million, sorry, 1.56 million for 60% that you had mentioned, is that an amount that you are comfortable with? Is that something that you are proposing? Or it's just something that you are asking Jonathan about?
Right. So my question with regards to 1.56 million was just a clarification, given that
All right,
based on what the information that they had to offer, that it would amount to a valuation of
right.
1.56 million.
Okay. You're still requesting for the 2.6 million buyout, just for
Uh,
clarity.
Right. So I think, just to clarify, given that there's already a large difference in positions, and I don't want to stretch this further, just to sort of, I think, simplify it more further, in keeping aside all the percentages and valuations, ideally what I would be looking for is a buyout of 1.8 billion at the lowest. Again, this is contingent on my role this is contingent on me continuing as my role in directors for as a co-signatory, as I just mentioned earlier. But again, before I go any further, I'd just love to hear from Jonathan on what his thoughts are on the same.
Just to clarify, since there's a lot of facts that said, what we are looking for is a 1.8 million. Setting aside all the percentages, since we have a different valuation, we don't want to have that conversation. $1.8 million as a buyout money, and all this is in consideration of our second agenda, that is future role of Mira in the company, and some concession will be needed in that angle, because this concession is not only just for Mira, it's in consideration of the fact that, first of all, we have already said 2 Indian suppliers worth 700,000 will terminate their services if there is no stability. And not only that, the Dubai credit facility that we get $500,000 from, that is due on January 2026, they will also terminate their services if there is no joint management. So this $1.8 million that we are offering is in condition that Mira makes concession on the second agenda, that is her future role in the company. Is that clear?
Yeah.
I just have a small question to ask. Hey, please go ahead if you want to do it. Please do.
Yeah, I just wanted to just ground us quickly. I know that we've been at a bit of an impasse between, wanting two different things. So I just wanted to keep in mind that, the give and take part of this. So, seeing if there's any concessions that either team can make when considering this new offer and moving forward. And with that, I'll pass you back the floor for the clarifying question.
Thank you so much. We are open to making a few concessions, which I believe we already proposed. I just wanted to hear your perspective very briefly on one thing. Are you looking at this company as a matrimonial asset?
Sorry, I think I wasn't able to hear you properly. If I could just get a repetition for the same.
I'm so sorry. Am I audible now?
Yes.
Oh, yes, it's perfect.
All right. Are you looking at this company as a matrimonial asset which is going through divorce proceedings? Because our official communication with respect to the buyout was contingent on that particular factor. So I wanted to hear your perspective, whether you're even open to it or not. Because us discussing numbers will not take us anywhere if we are at two different perspectives with respect to this. So I just wanted a small clarification on this.
Again, I think primarily, as I said earlier, my two concerns are a fair, equitable payout and being still involved in the company. Given that those two are met and I'm made do well of my own of my contributions to the company, I am amenable to going ahead with what you are offering. But then again, that is on the contingent. That is contingent on me getting that fair payout that I just mentioned, and additional on top of that, also being involved in the company directly.
So, seeing that you've agreed to drop all charges if we reach an agreement regarding whatever demands you've made, and in the spirit of going forward, I would like to just on behalf of my client make one consolidated offer. However, before I complete that, I would appreciate that I'm going to make a consolidated offer right now, but we discuss it in two halves because this is getting mixed up a lot in my opinion. So the very first offer about the buyout. We believe that since our my client has made some disclosures to the mediators, which I hope they will understand and be able to convey to you better. How we might not be able to be in no position to raise our offer of 1.2 million. However, we can pay it to you right now. In exchange of the again, the valuation that we're doing stands at 2.6 million. The 55 percentage that we're discussing earlier was the effective value as to what role each one of us holds in this company right now. However, getting into the technicality is not the part because now we've reached the conclusion that a buyout is going to happen. So we both acknowledge each other's roles. It's just the value that we're about discussing right now. So 1.2 million right now. As far as the future is considered, uh, the second this is the second part that we would like to discuss separately in the second agenda. Mira's continued role is that this buyout of getting completed will be at the end of the divorce proceedings because as I've made it clear earlier, if this company becomes an asset of either one of the parties completely before the proceedings begin or get over, they would come into the proceedings and get split. So again, we until these proceedings are over, the 60/40 capital that Mira holds in this company is going to stay that we would like status quo in that regard. 60/40 until these proceedings are over. As far as assurances regarding the creditors as well as Mira being a signatory and not just in a consultant role is there, I would like to make the second half of my client's offer is that uh, as they said they roughly hold the 50%. The valuation that they're offering right now is 1 million. Any
I'm
they will
sorry. What was the valuation of 1 million?
the 1 million that they offered before this offer was revised 1.2 million. We would like to place that our initial valuation of Mira's stake in the company is 1 million. At this moment, effectively, not getting into the details of that, but we would like to keep that 1 million here as a cap. As in, if Jonathan is to make a transaction through the company which exceeds 1 million US dollars, he would require to take Mira into consultation and also take her approval before making that transaction, just for the sake of there being transparency, since reservations regarding the management and the joint management is concerned. So about the joint management, the 60/40 arrangement will remain until the divorce proceedings, so the creditors will not get upset. Mira will get the assurance that she continues her role and because we are putting a cap as to how much maximum they can spend. However, keeping the holistic growth in mind, if this lasts past March 2026, we will need to revise the cap so that the company grows later. So that is something that we can follow up upon later.
I'm very
This was
sorry.
my second
Just
half of
to
the offer, if
Just to
I may be
clarify,
allowed to
Miss,
the offer put forward by the other party was a 1.2 million of a buyout plus a role in the company that basically defines that if there is a transaction of more than 1 million, Mira will be consulted. So
Yes.
1.2 million plus this role. These are the two things that Jonathan is offering from what I can gather.
And the status quo of 60/40, just to cap off whatever you said.
60/40 is 60% on our side, if I'm not wrong.
That's correct.
The equity split that has been there since the seed 60/40, that will continue. Status quo. No changes to the shareholding because that's a technical issue.
Provided that the allegations be dropped.
Yeah,
Those are the two.
because our end goal is to get away from litigation and to maintain the reputation.
Miss,
All of these are contingent to the allegations being dropped.
Mr. Nilay, you just to clarify so that we're all on the same page here, you had mentioned the 1.2 million buyout as the number as of now, but it's something that you are open to discussing more in the future.
As I said, we are not in the, my client is not in the position to increase it. What he can do is pay it upfront as soon as possible before the conclusion of the proceedings. So rather than paying a higher amount later, which he cannot, he can resolve this issue by paying it right now, and that just solves, rather than waiting for the period. In the case, this basically, the effect of paying it right now, let me just explain, is that in case things go haywire later, there is a chance that he may not be able to pay this money. Rather, he will pay it right now, and then later Mira does not have to worry about it. So the 1.2 million offer stands right now.
Right. I'm so
All
glad
right.
that the issue of the time for payment was brought up earlier, because ideally, given my circumstances right now, which again I'm not going to disclose right now at the present, but I would want the buyout to happen before before the ending of the divorce proceeding. Before the divorce proceedings are done with, I would want the buyout to go forward with the same. So I'm really glad that we are able to come to a consensus with that. But especially with regards to the payment, the amount of the buyout, I do think there is a substantial gap in our positions, given that right now at best you are offering 1.2 million, which is something that we are not amenable to, given that our valuation is currently stands at 1.8 million.
Miss Mira, sorry if I may interrupt. I think parties today we have made extremely admirable progress. I think we have established that both parties are interested in the company remaining stable, and that we have put a lot of offers on the table so we can ruminate on what has been put on the table and we can discuss in further sessions. I think we've also established that a buyout is something that will be happening, but we can agree on the value in later sessions. It's not necessary that we come to a conclusion on our agendas in this session. We always have future sessions for that. So I'd once again like to thank the parties for being part of this mediation session, and we really enjoyed you being here today.
Thank you so
Ms.
much.
Hayden.
Right.
Thank you so much.
Yes. Yes, I just wanted to reiterate that was, a lot of different parts that's been discussed and managed very well. So I commend everybody coming in and balancing them and, conceding where possible and holding where it was important to you. So great job with collaborating together, and I'm looking forward to see what future discussions come out to. Thank you.
Thank you so much, Kylie.
Thank you so much to the mediators and for Jonathan for coming here in the spirit of collaboration.
Yeah, thank you so much, Kylie and Haley, for all their collaboration and everything. But I'm glad we came to agreement on the buyout factor. I think we can schedule the next mediation session as soon as possible, if that's fine with the mediators.
John, would you like to thank them before I do?
Thank you so much, Kylie, Christo, and Mira for having a discussion today. I know there was a lot of back and forth which happened.